Hello, is this the office of Messrs. AAA?
Yes, it is. This is Arif speaking. How may I assist you today?
I wanted to set an appointment for me to come by the office. I want to consult regarding a situation I have.
Oh, sure, you can.
Yeah, do you think I could come by later today at 3 p.m.?
Of course.
Oh, that would be great. Thank you.
Hi Miss June, my name is Arif and together here with me is Amar. We are assigned by the firm to assist you on the case at hand.
Nice to meet you, June. Let's have a seat first.
Hi, hello. Mr. Arif from Salma. Thank you for having me. So basically, my father, Richard, owns a unit of a double-story bungalow, and he wishes to transfer half of his share on the property to me as a birthday gift. So my question to you guys is whether this transfer is permissible in the eyes of law, since I am his adoptive daughter, and what are the legal procedures in order to complete this transfer?
Miss June, initially, transfer of land as provided under Section 214, subsection 1 of the NLC provides that transfer can only be carried out in respect of the whole piece of land. This means that the transferor, which is your father, is prohibited from transferring half of the land to you. But don't worry, there is an exception to this, and we will be applying the principle in the case of Peter Lai Chin and another against collector stamp duties to your current situation.
To explain further, your case falls under an inter vivos transfer. It is allowed under the law provided that you fulfill all the conditions under Section 26, Paragraph A of the Contracts Act 1950.
Ah, I see. Actually, what is an inter vivos transfer?
An inter vivos transfer is a transfer of property from a transferor, which is your father, and the transferee, which is you, without any monetary consideration, or it is transferred to the transferee as a gift under elements of love and affection.
What about the conditions?
Firstly, the agreement shall be made in writing. The relevant dealing document to effect the transfer is provided in Section 215, subsection 1 of the NLC, which is Form 40A. Therefore, we will need your cooperation to produce a photocopy of your IC and your father's IC for us to fill in every detail required in the Form 40A. Aside from that, we will also use your details to fill out the CKHT forms. We also need you to give us the IDT of the land. Once everything is done, Form 14A must be registered for the transfer to occur.
Miss June, since you mentioned earlier that you are an adopted daughter, in that case, we require that you produce a copy of your original adoption certificate. This is provided under Section 9, subsection 3 of the Adoption Act 1952, where it will be regarded as a reference to indicate the adoption is in accordance with the law. This is also to ensure that the third condition is fulfilled, where the parties in the agreement shall stand in near relation. So near relation in your case will be a father and daughter relationship.
Understood. I'll hand in the requested documents as soon as possible. Is there anything more that I need to know before we end this meeting?
Yes, Miss June. Before Form 14A can be registered, an amount of stamp duty will be imposed to you depending on the property's market value. According to Section 16, subsection 1 of the NLC, you will still have to pay the full stamp duty despite receiving only half of the property.
Again, don't worry, Miss June. You are eligible for a 50% rebate because of your relationship with you and your father following the remission and exemption made by the Finance Minister back in 2002 and 2007.
That is amazing. Thank you, Arif, Amma, for your time and detailed explanation. I need to make a move now, and I trust that your firm will handle my case perfectly. Do contact me if you have any questions.
Thank you, Miss June. We will keep in touch with you and keep you updated on the progress.
Now for the next step, the documents that we should prepare is Form 14A. This is stated in Section 215, Section 1 of the National Code. Furthermore, Section 208 of the National Land Code says that to complete Form 14A, we will help our client to fill in the details required by the form. Among the details, the relevant details that must be included are the transferor and transferee's name, the national identification number, full address, and conjugal status. Furthermore, we are aware that Ms. June has reached the age of majority. Therefore, there shouldn't be any issue for her to participate to perfect the Form 14A. This is also in accordance with Section 43 of the National Land Code, which states that a natural person must attain the age of majority. Now, I have with me an example of Form 14A. There are certain details that must be filled out, such as what I said, the name, the full name, the address, and the IC number. Aside from Form 14A, there are two supplementary documents that should be included in the process. They are Form CHT1A and Form CHT2A. CHT1A is for the disposal of the land of the transferor, which is Robert Maxwell. CHT2A is for the acquisition of land, which is the transferee, June. Additionally, under the Real Property Gain Tax Act 1976, there is a 100% RPGT exemption in the transfer of property between family members by way of love and affection between spouses, parents, and children. The transferor is deemed to have received no gain and suffered no loss, and therefore is not subjected to any RPGT.
Now that the relevant forms have been filled out and prepared, what's left is to execute the documents, and it must be done by the parties involved according to Section 210 subsection 1 of the National Land Code. Next, Section 210 subsection 2 further states that the execution by the natural person, which in this case is our client and her father, must be done by signing Form 14A and the other two supplementary forms, namely CKHT1A and CKHT2A under Section 294 subsection 2 of the NLC. Moving on, it is important to note that there must be a witness to attest the executed document. This is in accordance to Section 211 of the National Land Code, which states that every execution shall be attested by a relevant officer such as a magistrate, an advocate and solicitor, and a notary public. However, for any advocate and solicitor who wishes to do so, he shall indicate that he holds a practicing certificate which is in force at the date of the attestation, and shall also indicate the reference number to which it relates. After the document has been executed and attested, then it must be produced to the stamp office for stamping. According to Section 16 subsection 1 of the Stamp Act, the document to be stamped are the duly completed Form 14A. Even though transfer under inter vivos does not involve monetary consideration, it still needs to be stamped by virtue of the said section. Hi Ms. June, this is Arif. Now that we have signed the Form 14A, all that's left is to send this, a copy of the IDT and also the PDS 15 to the stamp office for it to go through a process that's called adjudication. Once we have obtained the actual market price value through the adjudication process, we will proceed to calculate the stamp duty based on the calculation method as provided under item 32 of the first schedule of the Stamp Act. Once we know the cost of the stamp duty, 50% will be deducted since you are the child to the original landowner. Then only we will register the Form 14A. We advise you to pay the stamp duty within 30 days after the execution date as per Section 47 of the Stamp Act. If it is not paid within the time, then a penalty of late stamping will be imposed to you. Alright, thank you, Miss June. After the stamp duty has been paid, the transferor or the solicitor must present the document of registration as stated in Section 292 subsection 1 of the National Land Code. Furthermore, all documents must be presented for registration, must be accompanied by the prescribed registration fee according to Section 293 subsection 1 of the National Land Code. It is important to note that our team must first make an appointment under the Land Office e-Temujanji system before we could present the document to be registered.